I'm Dr. Richard I. Fine, founder and chairman of the Campaign for Judicial Integrity. Welcome to our website. Today, I would like to speak with you about my personal background, some of the things that I've done in my life as both a lawyer and a strategic consultant and the Consul General of Norway, the reasons for the forming of the website, and what you can do to rid our country of judicial corruption. Before we begin, I would like to ask you, have you ever been affected by judges' decisions? Think about it. Now that you've thought, you probably realize that you have. Or if you personally have not, that your family, friends, businesses, or business associates have. And have those decisions affected you in such a way that you've either lost money, been unavailable to see your children, have been involved in situations that were very, very disturbing? Chances are that you have. Do you want to cure those problems? Do you feel that the judges or the judicial system wronged you? Do you feel that the system was corrupt? I believe that the answer to those questions may very well be yes. Do you want to cure those problems? And do you want to cure those problems and make the system right? Rid the judiciary of bad and corrupt judges. If you do, you have come to the correct place. We have the solution, and we'll speak about that a little bit later. First, let me tell you a little bit about myself. I was born in the Midwest in Milwaukee, Wisconsin. I went to the University of Wisconsin undergraduate school and obtained a Bachelor of Science. I went to the University of Chicago Law School and obtained a Doctor of Law. I then went to the London School of Economics and Political Science and obtained a PhD in International Law. I obtained a Certificate of Comparative Law from the International University of Comparative Law in Luxembourg. I obtained a higher Diploma of Comparative Law at the Institut des Facultés for the Enseignement de Droit Comparé in Strasbourg, and I obtained certificates of Public and Private International Law at the International Academy of International Law at The Hague in the Netherlands. After I completed my university education, I then worked for an international law firm in London for a year while the United States government was doing my security clearances to go to work for them. While in London, I was engaged in dealing with international mergers as well as dealing with large international contracts. I then joined the United States Department of Justice in Washington, D.C., and worked for the Antitrust Division. And during that time, I dealt with international mergers. I did the first hearing of the Justice Department before what was known as the Tariff Commission, now known as the International Trade Commission. I investigated the international pulp, paper, and newsprint cartel and indicted and started the case against GM and Ford for price fixing. After a number of years with the Justice Department, I was brought out to Los Angeles to work for a private law firm where I did class action cases, securities cases, and other types of cases. And after a year with that firm, I was recruited by the mayor of Los Angeles, who at that time was Tom Bradley, who was just elected, to come into the Los Angeles city government to prosecute and go after the former mayor and his administration for corruption, where I was a special counsel to the Government Efficiency Committee, and then founded the Antitrust Division for the City of Los Angeles, which was the first municipal antitrust division in the country. After that, I then formed my own law firm, which was called Richard I. Fine and Associates. And in the time that I had that law firm, I did such things as change the way that United Way did business. For those of you that have a memory of these things, it used to be that when you gave to United Way, you could not designate where you wanted your money to go. I brought a case which changed that. And now when you give to United Way, you can tell United Way where you want your money to go instead of their forcing you to put the money where they wanted to do it. I sued OPEC on behalf of the International Association of Machinists, and that was the case of IAM versus OPEC. That case resulted in the Ninth Circuit determining that OPEC was a price fix, which we all knew, but then the Ninth Circuit said that because of what was known as the Act of State doctrine, it would interfere with our international relations. And that's why OPEC is still existing today and why the United States government does not go after OPEC. I reorganized the entire service industry in California with respect to the fixing of appliances, consumer electronics, and other things. I fought 2 cases in the United States Supreme Court by doing 2 amicus briefs. One of the briefs was quoted in the decision of the United States Supreme Court, and the other case won also. I saved and returned approximately $1 billion to the taxpayers of California of monies that were taken by the politicians through use of the budgets from trust funds and special funds. I closed down California state government in 1998 and literally stopped 26 years of budget crises. Because what would happen is that for 26 years, the California government would go and have a budget crisis, and the legislature would be stymied because they were unable to pass a budget. During this time, they would not pay welfare, Medi-Cal, monies due to the counties, and small and minority business owners that had contracts with the government. But what they would do is the governor would pay himself, they would pay the legislators while they were fighting, and they would pay the state employees. I obtained an injunction, closed down the government. Nobody got paid. The next day, they passed a bill for $19 billion. It was emergency legislation. Suddenly, everyone got paid. 5 years later, I won that case in the California Supreme Court. This became the first problem that the judges had, because in that point in time, I also stopped all the payments to the judges. As we went along, it was ruled that the judges had a statute that was allowing them to get paid, but that took a number of years. I also ended up doing things such as reorganizing a Japanese religion worldwide when a California Superior Court judge thought that he could determine who was going to control this religion, when the person who was controlling the religion had to be registered in Japan. I fought the first terrorist shooting at an American airport. These are just some of the cases that I was involved in. But then we came to a very interesting problem. In about 1999, what occurred is I was brought in to deal with a case in which the County of Los Angeles was taking $45 million a year of state environmental funds and putting it into their budget, the county budget that was. I came in and I won a judgment. I stopped them from doing that. I founded a special trust fund for these environmental funds. And then when it came time to get paid, the judge, Kurt Lewin, refused to pay me. And as part of his reasoning was that I was representing a county union, and he was saying that county unions shouldn't sue the county. And this went up through the Court of Appeals. I thought this was very strange because we reduced the fees for environmental fees that restaurants and other people had to pay across the board and froze them. Well, the next thing that happened in the same point in time, and this was 1999-2000, during this same time period, a man by the name of John Silva came to me with a very strange case. John Silva was divorced from his wife, and they were on friendly terms. And John Silva was paying child support, and he was paying child support through the county. And his wife wasn't receiving the child support. and we couldn't understand why. I looked into this and determined that Gil Garcetti, who was running the child support program, and Gil Garcetti was the district attorney of Los Angeles County, was keeping the money and not distributing it. Now, there was a law in place, and that law said that the district attorney could only keep the money for 6 months. He had to distribute it within the 6-month period of time if he knew where the mother and the children were. And if he didn't know where they were, he had to give the money back. And he and his office were not doing that. I brought a lawsuit on behalf of John Silva to have the money distributed. During what we call the discovery period, we discovered that Gil Garcetti was withholding $14 million of child support money. Some of this money was being withheld for up to 2 years. We went into the trial. Garcetti's office admitted to withholding the money, and as we got to the end of the trial, the county asked to have the case dismissed, and the judge dismissed the case. Totally strange and totally outrageous. When I got into the appeal process of that case, I became aware of a very astounding fact. The County of Los Angeles was paying illegal money to the judges. And that's how I became aware for the first time that the judges were receiving illegal money from the counties. Now, how did I become aware of this? Interestingly enough, I became aware of it because Chief Justice Ronald M. George of the California Supreme Court gave a speech on September 15th, 2000, to a meeting of the California Judges Association. And in that speech, he said that the payments by the counties to the judges were wrong and may be unconstitutional. That speech was reported in the Metropolitan News, which was a legal newspaper. From those words out of the mouth of the Chief Justice of the California Supreme Court, I began to do the research. And I then exposed this in the first briefs in the Silva case. Well, what happened is the Court of Appeal justices and even the Supreme Court refused to acknowledge this. In 2002, I then brought federal lawsuits. The first one against Judge Kurt Lewin and the County of Los Angeles for violating the United States Constitutional's Due Process Clause and also what was known as Article 6, Section 19 of the California Constitution with respect to these payments. And then a second one, also in 2002, called Silva versus the County of Los Angeles and various judges. Now, in both of these lawsuits, in the first lawsuit, Judge Matz, a U.S. District Court judge, dismissed the first lawsuit, saying, under a doctrine called the Rooker-Feldman Doctrine, that someone who had lost in the state courts couldn't bring a federal lawsuit. What Judge Matz ignored was the fact that if there was fraud upon the court in the state lawsuit, you could bring the federal lawsuit. So immediately you now have Judge Matz, a federal judge, covering up for the errors of the state court judges. In the second lawsuit, same judge, Judge Matz, ends up saying Silva didn't have what they called prudential standing to bring the suit. But that was also wrong because Silva had a divorce case going in the state court, and therefore he did have the standing to do it. And that went up into the Ninth Circuit, and they also said he didn't have standing, which was also wrong. But even more important, Judge Matz made a statement saying that you can't sue these judges for taking this money, and Judge Matz knew that there was a violation of due process, but even worse, Judge Matz knew that they were violating the intangible right to honest services, because a judge can't take money from a party that's appearing in front of him. It's a violation of federal law, federal criminal law, in fact. Well, life went on. In 2004, I brought a series of lawsuits against the County of Los Angeles and developers who were leasing land from the county, land in the area known as Marina Del Rey. Marina Del Rey is the largest private yacht harbor in the United States. It's 400 acres of water and 400 acres of land. And the county was leasing that land out to private developers. Now, this in and of itself was a violation of the California Constitution. But worse yet is they were leasing the land out, and the amount of money that the county was receiving from this land was paltry. The developers were receiving $300 to $350 million a year in rent from the apartment buildings that they put up on the land. The county was getting $30 to $35 million a year. According to the value of the land and the commercial rentals that were taking place at that time, the county should be getting $70 to $100 million a year. Over a 10-year period of time, the taxpayers of LA County lost between $700 million and $1 billion. As the case came on, I moved to disqualify the judge who was taking money from the county. The judge refused to disqualify herself, struck the disqualification. We went up into the Court of Appeals, and the judges in the Court of Appeals, who also were former LA Superior Court judges, ended up throwing out our writ and went up to the California Supreme Court and threw it out. Clearly, once again, you see the corruption taking place. We then come to another case, and this case is the case that landed me in jail and got me disbarred. This was a case in which a man by the name of Jerry Epstein, who had an apartment building in Marina Del Rey with 252 apartments, and he wanted to redevelop it into 500 apartments. And he needed an environmental impact report. And he was in front of the commission that would give this environmental impact report that then had to be approved by the County of Los Angeles. And I was retained by the group next door, which is the Marina Strand Colony 2 Homeowners Association, to deal with this environmental impact report. About the same time that I was retained, the state bar filed charges against me to try and remove me from the state bar. Now, previously in 2000, this is in 2006, in 2003, the judges had gone to the state bar to try and get rid of me. And they lost. I moved to dismiss the case right before trial. They knocked out. Unbeknownst to me, in 2004, a person by the name of Bruce Mitchell, who was a defendant in one of my federal cases, secretly had gone to the state bar and filed a complaint. That never became public until 2007. In 2006, the state bar came in and said, "We've conducted our own investigation," and they came against me. Now, sitting at this point in time as the president of the state bar was a man by the name of Sheldon Sloan. He was Jerry Epstein's lawyer in another case that I had against Epstein with respect to Marina Del Rey. Another person who was the new incoming president of the state bar was the lawyer for the County of Los Angeles negotiating a renewal of the lease with Epstein. A third person sitting on the Board of Governors of the state bar was the controller of the city of Los Angeles, who I had exposed in a third case where she took a behest in her name of $5,000 from the Playa Vista Corporation one day after she gave a report which was favorable to Playa Vista. So you now have three members of the Board of Governors of the State Bar who wanted me out of commission because of cases that I was involved in directly with them. Their failure to disclose that was a misdemeanor. They never disclosed these things. The case goes on. I bring the case against Epstein, which was called Del Rey Shores, and the defendants were Del Rey Shores Joint Venture and Del Rey Shores Joint Venture North. The judge was David P. Yaffe. David P. Yaffe never disclosed that he was receiving money from the county, who was the defendant. Epstein's lawyers never disclosed this, and the county never disclosed this. Yaffe should have been out of the case. But what was even worse is that the county approved the EIR. Now a problem developed, and the problem was this. Epstein had given thousands of dollars 6 weeks to two county supervisors, Antonovich and Kanabi. And he gave this money 6 weeks before the county voted to approve the EIR. There were 5 county supervisors. 4 of them voted to approve the EIR. The problem was that because Antonovich and Kanabi had received campaign contributions from Epstein, they couldn't vote. But they did. And the county covered up the vote. While this case was going on, the state bar held me to be involuntarily inactive. Now, the state bar judge that did that was a member of the Board of Governors of the Southern California Special Olympics. While he was the judge on the case, the county gave $15,000 to the Southern California Special Olympics. He didn't disclose this, and nor did the county, but I found out about it, and he refused to recuse himself. In addition to that, sitting on the Board of Governors with him of the Southern California Special Olympics was a lawyer from the law firm which gave the $5,000 behest to the city controller, which I mentioned before, which is on the Board of Governors of the state bar. So you have all these conflicts of interest and all this money flowing back and forth. I went off of the case. Now, at the time that I went off of the case, the county was 60 days late in producing the record in the Epstein case. I was 1 day late in asking for a trial. The county and Epstein moved to dismiss the case because I was 1 day late. I responded in saying that if you dismiss it, you have to reinstate it, which is what the law said. And also, I should win because they were 60 days late in producing the record. I'm now gone from the case. And this happened in October 2007. New lawyers come in. In January 2008, I get a notice saying that Judge Yaffe has dismissed the case and reinstated the case, and then also refused to grant a win to my side, saying that no harm, no foul with respect to what happened with the county. And then he says that I should pay money to the county's lawyers and to Epstein's lawyers for their legal fees in getting the case dismissed and then reinstated. Well, the law says that that doesn't take place. So when I heard about this, I came in and I moved to have all of this taken away because, first of all, I received no notice of it, which is a constitutional violation. But second of all, I said, Judge Yaffe, you've received money from the county. You can't sit on this case. You can't do anything, because we had never had a hearing in front of Judge Yaffe in this case. This was in February 2008. Judge Yaffe responded on March 18th, 2008, saying that I didn't have standing to remove him. Now remember this date, because it becomes very important. On March 20th, 2008, there's a hearing in front of Judge Yaffe. And I say to Judge Yaffe, are you receiving money from the county? Judge Yaffe admits it. He says, yes, I'm receiving money from the county. I tell him, you have to get off the case. You're disqualified. He doesn't do anything. The next thing, I then file a disqualification. Judge Yaffe doesn't respond. The law says if the judge doesn't respond within 10 days, he's gone. Judge Yaffe should have been gone. He didn't go, and he didn't send the case back to the central judge for reassignment. Judge Yaffe then enters an illegal judgment against me for $40,000. Then they try and enforce the judgment, trying to find out my assets and getting me to testify where they are. I refuse to do that. Judge Yaffe then holds a contempt hearing, saying that I'm in contempt for refusing to disclose my assets on an illegal judgment. I tell Judge Yaffe, you can't have a contempt hearing because you're getting money from the county. You can't hold a hearing which is judging your illegal actions. I put Judge Yaffe on the stand. Judge Yaffe is now a witness on the stand testifying where he is also the judge. Life doesn't get more unconstitutional than this. We go through the entire contempt hearing, and Judge Yaffe holds me in contempt for not disclosing my assets. Sentences me to coercive solitary confinement in the LA County Jail until I tell them where my assets are. I was in solitary confinement for 18 months. This case went all the way up to the United States Supreme Court. Now what happens is we go into the district court, and the district court doesn't even know what it's doing, doesn't really look at anything, and decides against me. I go into the Ninth Circuit, and in the Ninth Circuit we have three judges. Judge Reinhardt, whose wife, Ramona Ripston, is the head of the ACLU in Southern California. The ACLU is receiving money from the County of Los Angeles to look over the jail, so he should be out. The second judge is Judge Stephen Trott. Stephen Trott is a former deputy district attorney in Los Angeles County and is receiving, at the time that he's judging this case, a pension of $11,000 a year from LA County. He should be out. The third judge is Judge Kim Wardlaw. Kim Wardlaw is married to her husband, Wardlaw, who's an investment banker, which according to articles and everything else is investing money for LA County, but also her financial report shows heavy interests and investments with respect to LA County. She should be out. I have three judges who basically have financial interests in LA County. What do they decide? They decide that, number one, Judge Yaffe doesn't have any bias against me. Number two, that the payments going to Judge Yaffe are not a constitutional violation when the case law says that they are. And number three, that these payments really, aren't really that relevant, which the case law says that they are. We go into the United States Supreme Court, and the United States Supreme Court does nothing. Now, at the time that I am 14 months in solitary coercive confinement, having gone outside maybe 15 hours, in which time I was only in a cage, basically what happens? Now, I want you to remember that date, March 18th, 2008. Judge Yaffe comes out in July 2010. He says, oops, I never made that order that fine could challenge my standing. I was wrong, never made the order. So now Judge Yaffe admits that way back at the beginning of all this, I really did have the standing to challenge him. That removes everything that he's done. And at the same time, he's now realized that everything that he's done is wrong. Now, in the meantime, I'm moving to try and get out of jail, setting hearings, and the sheriff's department is refusing to transport me to the hearings. In September, Judge Yaffe, September 16th is the exact date, Judge Yaffe says he's never going to let me out of jail. Now, the law says I should have been out of jail a long time ago. September 17th, Judge Yaffe changes his mind. Now, this is a very, very interesting thing for those of you that are spiritual. On September 16th, this was the day before the most holy of Jewish holidays, Yom Kippur, I was visited by 3 Hasidic rabbis. And they said that they're going to contact Judge Yaffe. I don't know if they ever did. September 17th, all of a sudden, Judge Yaffe changed his mind, decided that I would never give in, felt that I was taking the places of real criminals, and by saying I would never give in, he claimed that, I was of such a nature that that would never happen, and that he had kept me in jail to teach other people a lesson and set me free on what was called Kol Nidre evening, which was the most holy day of the Jewish calendar. Was there an intervention of God or anything else? No one knows. But it was very, very strange. Judge Yaffe then retired, in quotes, and went out of office. Very shortly thereafter, Chief Justice Ronald M. George of the California Supreme Court retired, in quotes, without giving a reason. Now, Chief Justice Ronald M. George, according to his biography, at the time that he was a Superior Court judge, would have received illegal payments from LA County. Within a few months after that, Carlos Moreno, an Associate Justice of the California Supreme Court, who also, according to his biography, when he was a Superior Court judge of LA County, would have received illegal payments from LA County. So you have Judge Yaffe retiring, you have the Chief Justice of the California Supreme Court retiring, and you have an Associate Justice of the California Supreme Court retiring, all within the short period of time of Judge Yaffe admitting that the order that he claimed he made didn't exist. Now, the story gets even more strange. My disbarment next turns out to be void. In 2011, the state bar came out with a statement saying that I was disbarred for bringing those 2 cases back in 2002. Well, I was never charged with that. So the state bar admitted that the disbarment was a fraud. I then moved to have the void disbarment removed and set aside. The California Supreme Court refused to do it. On the 3rd motion that I made, the state bar wrote a letter. They never opposed my motions. On the 3rd motion, the state bar wrote a letter to the California Supreme Court telling them, we are not opposing this motion. If you want us to oppose it, say something. Supreme Court never said anything, and they still refused to remove the void disbarment. That just happened in 2013. Right now, sitting on the California Supreme Court, you have 4 justices, according to their biographies, received illegal payments from counties when they were Superior Court judges, and a 5th justice who wrote what is known as SBX 211, which gave these judges retroactive immunity from criminal prosecution, from civil liability, and disciplinary action. But getting even worse, in December 2012, the former public information officer of the LA Superior Court, Alan Paracchini, in an interview with the Full Disclosure Network, admitted that when he became the public information officer in 2002, the judges told him that they had a visceral hatred against me, that they wanted revenge against me, they wanted to silence me, and they wanted to take me out of circulation for my having exposed these payments, brought the cases against these payments and brought them in front of the court and brought them in front of the legislature. So that gives you a background of what has happened to me with respect to these payments and what has happened to other people. Because remember, these payments have affected every aspect of the court system. Anywhere where the county is involved, from family law cases to eminent domain cases to criminal cases to accident cases, right across the board. You have judges who were disqualified, who didn't admit to the payments, and whose decisions were void. So that gives you the first part of the background. Now we come into, based upon that background, why did I form the campaign? In 2012, by this point in time, I realized that no one was doing anything. By this point in time, I had gone to Attorney General Holder to have the judges prosecuted for the violation of the intangible right to honest services. He had done nothing. I had gone to Jerry Brown when he was the Attorney General. He had done nothing. Gone to Kamala Harris. She had done nothing. I had gone to the U.S. attorneys. They had done nothing. I knew that nobody within government was doing anything. So the campaign was initially formed before the 2012 elections to have people vote out the judges. And we had a little bit of headway. Then, by 2013, I realized that the only way that we are going to get rid of these judges and also deal with the federal problems is to put together an amendment to SBX 211, and that amendment would, number one, remove from office the judges and the supervisors and anyone else that got this retroactive immunity from criminal prosecution, civil liability, and disciplinary action, would stop any payments into the state pension funds for the judges, would stop any consent of the state to any continuing payments, and would force the state to go in and track any payments that are still continuing. So I wrote the amendment and sent the amendment to every legislator. That's all been accomplished. So now we have the campaign set up with everybody knowing about the amendment. What becomes the next step? The next step is for you, the voters, to exercise your rights and to contact your legislators to get the amendment passed. So now we're at the action part. What can you do? And why do you want to do it? We go back to the very beginning. Have you been injured by a judicial decision or by a corrupt judge? If you have, do you want to do something about it? This is the only thing that you can do. Protesting in the street isn't going to get you anywhere. Making music or noise is not going to get you anywhere. Exercising your right will get you somewhere. How do you do it? You exercise your right by contacting your legislator, who's your representative. They work for you, and you tell them what you want done. And if they don't do it, you tell them again what you want done. And if they don't do it, you vote them out. And you keep voting them out until you get someone that does what you want done. Now, how are you going to do that? You come to our website. Now, you're already here. You go to the part of the website that says how you do it. And you literally put in your name, your address, your email. You press the button, or really the little point that tells you what to do, and letters will go out to your legislators. And if you're not from California, letters will go out to your senators and to your congresspeople. And we will get the amendment passed. We will start investigations in the federal government, and we will get this done and pass this on, because the more people that we get involved, the more pressure we put on. And remember, I'm going to leave you with a saying from Margaret Mead. Never doubt that a small group of intelligent, dedicated citizens can change the world. Indeed, that is the only thing that ever has. And remember, exercise your rights and vote for justice. Thank you.